The HOA president tried to fine me $100,000. Here's what happened. It all started when I moved into my new house. My wife and I had been searching for the perfect house for over a year in one of the most expensive real estate markets in the United States, Northern Virginia. We finally found our dream home, which just so happens to be located inside an HOA. Now, we really didn't want to buy a house that was part of an HOA, but this house met all of our requirements and it was move-in ready, so we decided to go ahead with the purchase. After we closed on the house, we received a welcome packet from the HOA. In this packet was the HOA governing documents. These included the covenants, conditions and restrictions, or CC&Rs for short, the HOA bylaws and the current board of directors. Now, my wife and I read through these documents, and everything seemed to be in order. We paid our HOA dues, and we were officially homeowners. For the first few months, things were great. But then, out of nowhere, the HOA president knocks on our door and tells us we have 2 violations. Now, we asked the HOA president what these violations were and how we could resolve them. He said that we needed to remove the basketball hoop and the volleyball net that was up on our property. To be honest, we weren't even aware that these items violated any rules. After all, they had been there since the previous owner had owned the house, and they also had been there when we did our walkthrough as part of the purchase agreement. The HOA president told us that we would need to come into compliance by next week, or we would be fined. My wife and I talked about it, and we decided to leave the basketball hoop up because we planned on putting it to use. We figured the worst thing that could happen is that we would have to pay a small fine. So we ignored the warning and we kept the basketball hoop. 1 week later, we received a certified letter from the HOA stating that we were in violation of the CC&Rs and demanding that we pay a $100 fine. Of course, we were very upset. First, we were never given a reasonable opportunity to cure the alleged violation. Second, the amount of the fine was unreasonable. The HOA claimed that the fine was outlined in their CC&Rs, which stated that a violation could result in a fine of up to $100 per day. But where in the document did it say that? Well, we went to the section in the CC&Rs that outlined the fines, and sure enough, it said that a violation could result in a fine of up to $100 per day. We were furious because it appeared as though the HOA had padded the fines in their CC&Rs. We looked at the date that the CC&Rs had been recorded and the date that the HOA sent us the letter. It had only been 7 days since the deadline they gave us, yet they were already assessing us the maximum fine. This meant that they were assessing us a fine of $700 per violation. And we had 2 violations, meaning that we were being fined a total of $1,400. Now, my wife and I were done playing games with the HOA, so we decided that we were not going to pay this fine. If they wanted to take us to court, then that's where this would end up. The HOA must have thought that we were bluffing because they decided to take us to court. They filed a lawsuit in the state court alleging breach of contract. The HOA argued that the governing documents constituted a contract between them and us. They claimed that under the terms of this contract, we were required to remove the basketball hoop and volleyball net. The HOA also claimed that we had breached this contract by not removing the basketball hoop after we were given notice of the violation. As a result, the HOA demanded that we be forced to comply with the CC&Rs and that they recover $1,400 in damages. We responded to the lawsuit by filing a motion to dismiss. In our motion, we argued that the case should be thrown out because the HOA was trying to enforce an illegal restraint on our use of our property. We attached a copy of the deed to our motion, and if the HOA took the time to actually read it, they would have realized that our entire property is subject to a homeowner's warranty deed restriction. This warranty deed restriction prevents the HOA from ever restricting our use of our property. Since the entire purpose of the HOA was to restrict our use of our property, the HOA was illegal. Therefore, none of the provisions in the CC&Rs could be enforced. After we filed our motion, the HOA tried to save face by amending their complaint. Instead of pursuing a claim for breach of contract, they now claimed that we had violated a restrictive covenant. Under Virginia law, a restrictive covenant is a promise made by a landowner that runs with the land and benefits the other landowners in the neighborhood. These types of covenants can help maintain property values and ensure that everyone in the neighborhood follows the same rules. However, restrictive covenants cannot violate public policy or be unconstitutional. A good example of a valid restrictive covenant would be a provision in the CC&Rs that prevented a homeowner from running a commercial enterprise out of their home. This type of covenant protects the other neighbors from increased traffic and noise that might be associated with a commercial enterprise. Now, we responded to the amended complaint in the same manner. We pointed out that the entire property is subject to a homeowner's warranty deed restriction, which renders the HOA's claim of a restrictive covenant absolutely meritless. We also pointed out that the HOA was likely colluding with the previous owner. You see, when we purchased the house, we also purchased the personal property that was on the property. When we went to record the deed to our house, the title company informed us that we needed to file a separate document to make sure that we owned all the personal property that was on the property. This included the basketball hoop and volleyball net. We filed the appropriate document and we paid the recording tax. So when we received the lawsuit from the HOA, we checked our records and we discovered that the previous owner had failed to file the appropriate document. This meant that the basketball hoop and volleyball net actually belonged to the HOA. So if the HOA was able to somehow get the previous owner to convince us that these items were ours, they would be stuck with these items after we sold the house. So we decided to check with the previous owner. We called the number that was listed on the deed. We explained the situation to him, and he admitted that he was working with the HOA to sell the house to us. We told him that we had evidence that he was trying to unload these items onto us. He told us to prove it. So we sent him a certified letter requesting that he admit that we purchased these items from him along with the house. He received the letter but refused to sign for it. Once we had proof that he was trying to pass off these items to us, we stopped communicating with him. Then we sent a demand letter to the HOA, giving them an opportunity to return the basketball hoop and volleyball net. They ignored our demand. So we filed an answer to their lawsuit and a counterclaim for conversion. In our lawsuit, we were seeking the return of the basketball hoop and volleyball net and monetary damages for the value of the items plus punitive damages. In our counterclaim, we were seeking the return of our money along with compensatory and punitive damages. After we filed our counterclaim, the HOA filed a motion for a preliminary injunction. They sought an order from the judge requiring that we remove the basketball hoop and volleyball net pending the outcome of the lawsuit. The HOA argued that they would suffer irreparable harm if we were allowed to keep the basketball hoop and volleyball net. The judge heard the arguments and issued an order granting the HOA's request for a preliminary injunction. The judge ordered that we remove the basketball hoop and volleyball net within 30 days, or we would be held in contempt of court. We decided to appeal this ruling to the Virginia Court of Appeals. During the pendency of the appeal, we continued communicating with the HOA, demanding that they return the basketball hoop and volleyball net. But the HOA refused to do anything. Then something bizarre happened. The HOA president called us and asked if we would be willing to settle the case. We told her that we would be willing to settle the case if she returned the basketball hoop and volleyball net. She told us that she wasn't authorized to make that decision. She said that we would have to speak with the attorney. We said that we would wait to hear from her. A couple of weeks later, the HOA president called us back and asked if we would be willing to settle for $5,000. At this point, We had already spent more than $5,000 in attorney fees. We had also missed out on selling the house because of the injunction. So we decided to accept the offer. We sent the HOA a demand letter outlining the terms of the settlement. The HOA agreed to the terms and we closed the file. But here's the kicker. A few days after we settled the case, we randomly ran into the HOA president at the post office. We were grabbing some documents from the mailbox. She was also getting some documents from the mailbox. We asked her if she had talked to anyone else about the settlement. She told us no. We told her that she shouldn't talk to anyone else about the settlement because it could impact the validity of the release. She told us that she had already talked to someone. She wouldn't tell us who she talked to, but she did admit that she talked to the HOA attorney. We were kind of concerned at this point because the HOA attorney was representing the HOA in the lawsuit. So we filed a motion to compel discovery in the event that the HOA tried to go back on their word. Then something else happened. The HOA sent us a refund check for the $5,000 that we paid them. On the memo line of the check, it said payment in full settlement of all claims. We cashed the check, but here's where it gets crazy. About a month later, the HOA calls us and tells us that they are rescinding the settlement. They demanded that we pay them $2,500. We, of course, refused. They threatened to sue us for the $2,500. We told them to go ahead. A few weeks later, we received a summons and complaint from the HOA. They were suing us for the $2,500. We, of course, filed an answer denying the allegations. We also counterclaimed for the return of the $5,000, alleging that the HOA was trying to unjustly enrich themselves. The HOA tried to amend their complaint, but the court denied the amendment. The HOA got the hint, and they dismissed their lawsuit. So, fast forward to today. We've now been living in the house for over a year. The basketball hoop and volleyball net are still up, and we're on good terms with the HOA. Oh, and by the way, we never mentioned that my wife is a federal district judge.